tongue, can I ask which case you're here on?
Your Honor, I'm with Mr. Noe and Michael Isaac today.
All right.
I can't see that.
And Mr. Owens, sometimes we get noise from MDOC. If I pop you in the waiting room, it's just because I'm having some noise interference, okay?
Yes, ma'am.
Okay. All right, so is your client in the courtroom, you said?
Yes, Your Honor.
All right, let's get you. This is in the matter of the people of the state of Michigan versus Brandon Lee Hurd. Grab your file. File number 25-22352FH. I have Attorney Brian Montoy appearing on behalf of the defendant and Phoebe McClure appearing on behalf of the people. I have received an amended felony information with count 1, criminal sexual conduct 2nd degree, which is a 15-year felony, and count 2, prostitution engaging the services of a minor, which is a 5-year felony, along with a plea agreement form that states that Mr. Hurd will plead guilty to count 2 and will be sentenced to probation with no immediate jail imposed in all appropriate terms and conditions, including but not limited to sex offender treatment and substance abuse treatment. That is the Killebrew agreement between the people and the defense counsel. Count 1 would be dismissed. Restitution, if there's any, would be determined by the court. Is there anything else to the plea, Mr. Montoy?
Your Honor, everything you said is correct, except for he will be pleading no contest based on lack of.
Oh, I'm sorry. I'm sorry. So, okay, no contest. Is that a correct recitation of the plea, Miss McClure?
It is. Can I pop into Miss Arnold's office and see if she wanted to be present for the plea? Just because it's no contest, she might want to make the factual basis.
Okay.
Thanks. Judge, I do have Miss Arnold here. She's having computer issues, so she's going to use mine. She just put the plea on the record, so.
And now I have Allison Arnold appearing on behalf of the people. So, Mr. Hurd, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, so Mr. Owens, I'm gonna pop you in the waiting room, okay? We'll bring you back. All right, now, you have heard the statement that I read and that your attorney agreed to and that the prosecutor acknowledged. So is it your intention today to plead no contest to count 2, prostitution engaging the services of a minor, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine, and does require registration as a tier 1 offense under the Sex Offender Registration Act? Do you understand all of that?
Yes, Your Honor.
You've discussed the Sex Offender Registration Act with your attorney and you understand what will be required of you?
Yes, Your Honor.
Okay. Are you satisfied with Mr. Montoy as your attorney and the advice that he has given you?
Yes, Your Honor.
Okay. And you'll be pleading no contest, correct?
Yes, Your Honor.
Okay. Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence outside of the Killebrew agreement with the court. Is that correct, Mr. Montoy?
That is correct.
And Miss Arnold?
Yes, Your Honor.
And is that correct as far as you're aware, Mr. Hurd?
Yes.
If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to hand down to your advice of rights. Did you already do those? Oh, I've already got them.
We did. Your Honor.
Yep, I've got them already. Yep, I've got them. Thank you. Okay, if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. Basically what this means, the law has changed. If you violate any bond conditions, you committed a new offense, or you get in trouble in any way, I don't have to honor the Killebrew agreement and you won't have a right to withdraw your plea. Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have it? And you understand that by entering this plea, you will be required to register under the Michigan Sex Offender Registration Act.
Yes, Your Honor.
All right, do you have any questions about the rights that I've given to you? All
No, Your Honor.
right, so your response will be no contest or not guilty. So, sir, how do you wish to plead to the charge that on or about the time period of June 6th of 2024 through April 3rd of 2025 in the village of Clinton in the county of Lenawee that you did commit the offense of prostitution, engaging the services of a minor?
No.
Okay, has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Montoya.
No, Your Honor.
Miss Arnold.
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be outside of the agreement?
No, Your Honor.
Is it your own choice to plead no contest?
Yes, Your Honor.
All right, who will be placing the factual basis upon the record, Ms. Arnold or Mr. Montoya?
Your Honor, I did provide the court a copy of the police report.
I don't do that.
I can do it. According to the Clinton police report number, which is 2500000998, during the dates charged, during the time frame charged in the information at 820 Tecumseh Road, apartment 82, which is in the village of Clinton, Lenawee County, state of Michigan. The victim, LH, who was age 9 at the time, disclosed that the defendant touched her butt under her clothes with his hands. She said she went into his room because she had an upset belly. He lifted the covers for her to come into bed. She then crawled on top of him. He pulled her pants and her underwear down before he pulled down his own underwear. He was rubbing her butt with his hands. She said she had to go to the bathroom to get out of it, and she described their position as laying chest to chest with her legs in between his private area. I believe that's enough to set up a factual basis for the original charged offense of criminal sexual conduct, second degree, and I'd ask the court to take that factual offense for the charge to which the defendant is pleading.
All right, Mr. Montoya, anything to add?
No, Your Honor, no objection.
Okay, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about the time period of June 6th of 2024 through April 3rd of 2025 in the village of Clinton in the county of Lenawee, that the defendant, for purposes of the plea, did commit the offense of criminal sexual conduct second degree, but for purposes of the plea to count 2, that he did engage in sexual conduct with the 9-year-old by removing her pants, his pants, and touching her butt while they were naked for the purposes of sexual gratification. And therefore, the court finds that the defendant did commit the offense listed count 2, prostitution, engaging the services of a minor by satisfying the elements of criminal sexual conduct second degree. And the court will accept the no contest plea. All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Montoy
Yes, Your Honor.
and Miss Arnold?
Yes, Your Honor.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this court case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them outside of the Killebrew agreement struck by the prosecutor's office and the defendant. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Montoy, are you available on, I know what date we're using, December 12 at 8:15?
Yes, Your Honor.
All right, so we will set this for sentencing on December 12 at 8:15 in the morning. Ms. Arnold, is there any preference with regard to being present in person or via Zoom?
I don't have a preference, whatever the defendant would prefer.
Montoy?
We're gonna come in person. Your Honor.
Okay.
Okay.
So it'll be in person. All right, a couple things, Mr. Hurd, when we get done here in the courtroom, we're gonna go directly across the hall to the probation department and check in. We're gonna get your contact information, a packet for you to fill out. And then also they may tell you today, or they may tell you at another day, time to come in and meet with them. Make sure your voicemail is empty and that it's set up to receive messages on your phone. When you meet with them, be truthful about your background. Obviously you entered a no contest plea, so you don't have to make a statement regarding this incident. And they will prepare a pre-sentence report. We'll provide a copy to Mr. Montoy. He'll review that with you before the day of sentencing. And we will see you back on December 12 at 8:15 in the morning in person. All right, thank you, Mr. Montoy.
Thank you, Your Honor.
Thank you, Ms. Arnold. So, let's see what I got. All right, Rhonda, if you could text message Mr. Glazier and let him know I have a gentleman from MDOC.
He's in, Judge.
I know,
after this.
I know. Just let him know his MDOC guy is here though. All right, I have somebody on an iPhone. I just sent you a request to unmute, a gentleman in a white shirt with a tie. Can I ask your name, please?
Yeah, it's Attorney Brad Hubble. I'm here with my client, Deshaun Mitchell.
All right. Okay, give us just a moment and I will take you in order. Mr. Goldstein. Let's see who you are here on today.
Dustin King, Your Honor.
All right. And then you have Zachary Rosenberg at 10, right?
I'm withdrawing that motion, Your Honor.
You're withdrawing, so Rosenberg's off?
Yes, Your Honor.
Well, thank you, Mr. Goldstein. All right, I'm fine. King. J. Oh, there it is. Is jail. Is Dustin King in the courtroom? No. Let's see if he's
Your
in
Honor,
our
he
waiting.
texted me. He thought it was Judge Morgan, so I just called him a minute ago. He should be working his way up from downstairs.
Okay. Was he in person?
Yes.
Okay, I have somebody on a device. I have sent your request to unmute. It says Zoom user. Could you see if Justin King's sitting in the hall? Could you unmute and tell me your name, please?
Nathan Lawrence.
All right, I'm gonna change your screen name. And who is your attorney?
We're ready on that, Your Honor, I believe.
Yeah, that one's mine, Judge.
Okay. All right, Mr. Lawrence, if you want to start your video. Is that the only one you had, Ms. Brenner?
Yes, Judge.
All right, this is in the matter of the people of the state of Michigan versus Nathan Edward Lawrence. File number 25-22395FH. I have Rhonda Underwood appearing on behalf of Mr. Lawrence, and I have Sarah Brunner appearing on behalf of the people. This is the date and time set for a pretrial conference. Ms. Underwood, how would you like to proceed?
Your Honor, this is Mr. Lawrence's first pretrial since he got out of jail and after paying bond, Your Honor. So we would ask for a 60-day adjournment for Mr. Lawrence to get his feet on the ground and start making payments, Your Honor.
Any objection, Ms. Brenner?
No, Your Honor, this is an all arrears case. So what I'm looking for is for the defendant to make consistent monthly payments so we can then do a delay of sentence to give him an opportunity to continue paying the balance down. So that's what I'm looking for from him when we come back, that he's made consistent payments for the next couple months.
All right, so Mr. Lawrence, and what did he post bond-wise to get out?
Let's see, his arrearages are down to 10,000 something now, so.
All right. So Mr. Lawrence, I'm going to adjourn this to December 17th at 8:30 in the morning. Write that down, December 17th at 8:30 in the morning. Ms. Underwood, you can do the step in order to adjourn, and Ms. Brenner, can she sign your name with permission?
Yes, thank you.
All right, so Mr. Lawrence, you need to start making payments on this, all right?
Yes, Your Honor. I'm actually getting ready to pay a lump sum this week.
Excellent, thank you. You have a good day.
Yes, ma'am. Thank you. Have a great day.
Thank you, Your Honor. Good to see you.
Good to see you too. Justin King in the courtroom? No, not yet. All right, Julia Betts, you want to step up, please? All right, this is in the matter of the people of the state of Michigan versus Julia Betts, file number 23-21519FH. Ms. Betts, we are here today on a couple things. First, I have a letter from Darren Coast and Pretrial Services, who advises that so far at this point, you've not been doing a good job staying up away from the alcohol. We have now 3 different days where your SCRAM device was tampered, where it detected alcohol. And so we have a motion affidavit in order to show cause that we have 3 confirmed tamper alerts, September 28th of 25 at 3:24 p.m. until 8:59 p.m., October 3rd from 3:47 p.m. until 10:49 p.m., and October 5 from 6:45 p.m. until 10:17 p.m. Those have been added to the prior show cause. So do you understand those are the violations against you on with regard to your bond conditions?
Yes.
All right, and then we have the other violation of probation from September 26th that again is the alcohol for September 26th of 25 and a potential domestic. So do you understand we have several allegations now that you violated your bond conditions?
Yes.
All right. Now you do have a right to have an attorney. You can, on these new ones, your underlying attorney is who on this case?
Underwood.
Rhonda Underwood. All right. So Miss Underwood is your attorney on this. Miss Underwood, are you in the building or another building?
One moment.
I can put her to the end of call if you're in the building is what I'm asking.
I'm sorry. Who is this? I was not.
Julia Betts. Julia Betts.
I am in the building, Your Honor.
So I'll put it to the end of my call, okay?
Thank you.
All right, so you're gonna have a seat, and when we're done this morning, Miss Underwood will come talk to you.
Thank you.
You're welcome. All right, Jasmine Sarabia. The matter of the people of the state of Michigan versus Jasmine.
I'm her brother. I'm expecting her here. I didn't know about she was supposed to.
What's your name?
Isaac.
Okay,
I'm her brother. So I'm
Well-
just gotta wait for her to be here.
well, I don't wait, so
My father's outside,
you guys are here, that's great, but if she's not here, it doesn't do me any good.
Yeah, my sister, please go and tell my father that she's supposed to be here. She's probably right down the street. We will pick her up right.
All right, I'll give you a few minutes to go get her.
I don't remember.
All right. All right, Dustin King, no Dustin King. All right, MDOC. Got. All right, in the matter of the people of the state of Michigan versus Deshaun Mitchell, he's with his attorney. I'm gonna call the jail for yours, Rhonda. You have Kelly Moe and do you have Michael? No, it's Noe. Kelly Moe. Hi, this is Anna Marie Anzalone. I am ready for Kelly Moe and Michael, no, I think just Kelly Moe at this time. Okay. All right, thank you. Bye. Okay, all right, Rhonda, I've called for them and he's in jail. Let me see. Jacob Kelly. I got him in the waiting room, Miss Underwood.
I just need to talk to him for a second, Your Honor.
Mr. Kelly, if you can unmute your device and start your audio, please. All right, this is in the matter of the people of the state of Michigan versus Jacob Dean Kelly. We have 3 files, 23-21287, 2 files, 23-21287, FH 24-21801, FH. I have Rhonda Underwood appearing on behalf of Mr. Kelly. These are for probation violations. I'm gonna pop you in the waiting room, Miss Underwood, and I'll sneak over to the next one with Mr. Hubble. All right, so, or I'm open up a breakout room, so hold on. And let's see. All right, go ahead and join that breakout room. All right, back to in the matter of the people of the state of Michigan versus Deshaun Mitchell, file number 25-22397FH. I have attorney Brad Hubble. What's your P number, Mr. Hubble?
It is P65455.
All right, appearing on behalf of Mr. Mitchell, and I have Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. So Mr. Hubble, how would you like to proceed today?
Yes, Your Honor, I can indicate to the court we've received discovery. I've been in discussions with the prosecutor's office, and I think we're at a point where we're going to be resolving this case. My client would ask that the court refer it for a Cobb's evaluation.
So if you wish to schedule one, you could just schedule that with my assistant. Okay, so I'm gonna give you a date and time for another pretrial. How far out would you like that?
Well, I'll defer to the court as to how long it might take to get the Cobb's report back.
So we don't do those in Lenawee County, so we don't have Cobb's evaluations or Cobb's reports. There are plea agreement forms that the prosecutor prepares if there's an agreement that's reached, or we do Cobb's conferences. So you can schedule a Zoom meeting with me and just the prosecutor to discuss any potential for Cobb's.
Okay,
Judge, if we could do 4 weeks, and I'll send an email with Mr. Hubble and Miss Adams and try and get a couple potential dates before then.
All right, so how about November 19 for a pretrial at 8:30 in the morning? Are you available that day, Mr. Hubble?
I am, Your Honor. Thank you.
All right, so November 19 at 8:30 in the morning. So Miss McClure is gonna send an email around. And then Mr. Hubble, I need you to prepare a stipend order to adjourn today's pretrial to November 19 at 8:30 in the morning. And Miss McClure, can he sign your name with permission?
He can, and if he prefers, I don't mind our office preparing that stipend order, if that's a little bit easier for him.
That would be lovely.
Do you mind if I
All
sign your
right.
name with permission to that?
Not,
Mr.
not at all, not at all.
All right.
Okay, all right, thank you. We'll see you back on that day or at the COPS conference. All right, thank you.
Thank you, Your Honor.
Yeah, maybe. Mr. Goldstein, we're gonna look for your client in Judge Olsaver's courtroom.
Okay,
All right,
I told him your courtroom, Judge, but I'm gonna call him right now.
Okay, so, Ms. Underwood, we're back on the record with Mr. Kelly. How would you like to proceed today?
Your Honor, could I have a brief adjournment? Mr. Kelly joined us from the hospital today. So I would like a chance to talk to Mr. Kelly under better circumstances. So if the court could adjourn this for a couple weeks.
Miss Adams, could I ask a big favor of you? Could I have my water on my desk, please? Miss Holly?
I do want to, I have not known anything about him being in the hospital. He was supposed to report yesterday and he did not, and I didn't get a call either.
Can I?
Yeah, I'd like to know why you didn't report.
I didn't. I was in the hospital. I wasn't even thinking. You must not deal with it. I'm so sorry.
Right, you are breaking up, Mr. Kelly, so we cannot hear you, but here's what I'm gonna tell you. You need to call Miss Holly today, okay?
Okay,
And then you will need to provide documentation of your hospital visit when you were admitted, all right?
Definitely. Yes, thank you.
I need you to report next Tuesday between 8 and 11 in the morning.
Okay, I will be there.
But I do need that hospital verification.
Okay, I will bring it.
All right, so Miss Underwood, we will adjourn this to November 19 at 8:30 in the morning because it's violation of probation. We can do the notice of hearing. All right, Mr. Kelly, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Mr. Goldstein, there isn't anybody in Judge Olsaver's courtroom.
Your Honor, I just spoke to Mr. King. He's in the building. That's all I can tell you.
All right, well, he's hiding. Okay, Mr. Moe, let me grab your file. This is in the matter of the state of Michigan versus Kelly Dwayne Moe. Wait, is that the right one? Yeah, file number 24-21931 FH. What's your name, sir?
Dustin, I'm downstairs.
Okay, all right, so hold on, Miss Underwood. Let me skip you for a minute. All right, what's your
Can I
last
have a
name?
breakout with Mr. Moe?
Yeah, all right, Mr. Goldstein, I think I have him. All right, I'm gonna open up a breakout room with Mr. Moe and Miss Underwood. Join that breakout room and go chat. Let me grab Mr. Goldstein's file. Where's that? Hold on, I gotta find it now. I don't know, I might have, JK, there we go. This, why don't you come up to the podium, please? Well, it's, you don't need witnesses today, so go stand at the podium. All right, this is in the matter of the people of the state of Michigan versus Dustin Michael King, file number 25-22419 FH. I have David Goldstein appearing on behalf of Mr. King. This and Phoebe McClure appearing on behalf of the people. This is the date and time set for arraignment in this matter, I believe. Mr. Goldstein, have you received a copy of the prosecutor's request for discovery, witness list, and felony information?
The answer to that is no, Your Honor, but I'm sure it's on the way. I'm familiar with the contents of the information, so we're prepared to proceed.
Okay, do you waive the reading of the felony information?
I do, Your Honor. My client
I'm
stands
sorry,
mute as
hold
a
on,
not
we
guilty
don't,
plea be entered.
hold on, everybody. So Mr. King, what is your
I got
question?
an email over to David on my health, over my brain tumor, my actinoid cyst.
Okay, that doesn't have anything to do with today. So Mr. Goldstein, do you waive the reading of the felony information?
We do, Your Honor. My client stands mute as that a not guilty plea be entered.
All right,
And Your
how
Honor,
far would you?
for the
what
record,
was-
that the information packet and arraignment documents were sent on October 13th, 2025 at noon. It indicates that it was successfully sent. It has not yet been downloaded. So if Mr. Goldstein has an issue with downloading that, just contact our office and we'll make
I'm
sure
sorry,
he
Ms.
gets that.
McClure, what day was that? The 13th?
Correct.
Let me check. I don't remember seeing it, but let me check.
Yeah, just reach out to someone in our office, our staff,
will.
and they'll resend it if you didn't get it. But it does say sent, just not downloaded.
Okay, all right.
I just wanted
So,
to make sure there was a record that we sent it.
So Mr. Goldstein, how far out would you like a pretrial on this matter?
About 3 weeks, Your Honor. Ms. McClure, I'm
Okay.
looking at the 13th and it was not received.
About November 12 at 8:30 in the morning?
Let me check that real quick, Your Honor.
But we can't have it. Because I got kids.
Yeah, that'll work.
All right, so I'm gonna set this for November 12 at 8:30 in the morning. Miss Adams, could I get a notice of hearing for Mr. King?
Yes, Judge.
All right, so see that bench right behind you? Have a seat right behind you and we'll get you a notice of hearing, okay? All right,
Ms. McClure,
Okay.
we do have it. It's labeled discovery. But I'm assuming that's what you're talking about.
Okay. I mean, it shouldn't be labeled discovery, but
Yeah, it is, but okay, we have it.
okay.
Thanks.
excellent. All right, so you need to be quiet unless you're being spoken to in the court. Got it? Because you're interfering with our audio recording. All right, so Miss Underwood is not back. So I've advised you to be quiet in my courtroom. Do you understand that?
I guess.
I can hold you in contempt and put you in jail. So my bailiff's gonna give you a notice of hearing. And then, remember, next time when you come, you have to be quiet in the courtroom.
I didn't know where.
Thank you. You can go. What'd you say?
I
Oh,
thought we had to sign something.
nope, thank you. All right, Miss Underwood, I'm gonna close the jail. And bring the gentleman back to you. What is your name?
I'm here today.
Okay. Anybody here have a hearing today? What's your name?
Dan Canablo.
All right, Mr. Knobloch, thank you. Mr. Glazier is your attorney, so he's next door, okay? All right, we are back with Mr. Moe. So, Miss Underwood, how would you like to proceed with Mr. Moe?
Your Honor, Mr. Moe is going to accept responsibility and plead guilty to the violation and the show cause. Or the
Okay.
violation in the bench warrant, Your Honor.
Okay, so, Mr. Moe, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I am.
All right, so Mr. Moe, we're here on a couple things. One, we have a violation of probation, which alleges that you violated your terms of probation by failing to report on June 4 of 2025 on both these files. And then we mailed a notice of hearing for you to appear for a probation violation hearing on July 9 of 2025, and you failed to appear to that as well. So those are the allegations against you. Do you understand that?
Yes, ma'am.
All right, you're currently on file number 24-21931FH on probation for breaking and entering, which carries a maximum penalty of up to 10 years. Your guidelines on that file were 19 to 35. And then on file number 24-22090FH, you're currently on probation for larceny in a building, which carries a maximum penalty of up to 4 years in prison if you plead guilty or found guilty. Do you understand that, Mr. Mo?
Yes, ma'am.
The failure to appear at a hearing is a contempt of court proceeding, and that carries a maximum penalty of up to 93 days in jail. Do you understand that, Mr. Mo?
Yes, ma'am.
All right. Now, I've been advised by your attorney that you wish to plead guilty to those today. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
Okay, so now do you understand that you have a right to contest the violation of probation charge and the contempt of court and have a trial on it? Do you understand that?
Yes, ma'am.
Do you understand that throughout the trial, you will be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, ma'am.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yes, ma'am.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, ma'am.
All right, and how do you plead to the charge on both of these files that you violated the terms of your probation by failing to report on June 4 of 2025 when you were released from jail to the probation department? Guilty or not guilty?
Guilty, ma'am.
And how do you plead to the charge that you failed to appear in front of this court for a show cause for failure to appear at probation on July 9 of 2025? Guilty or not guilty?
Guilty, ma'am.
All right. Do you understand by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes, ma'am.
Has anything been promised to you to get you to plead guilty?
No, ma'am.
Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Mo, at the time of sentencing, you were advised that you needed to report to the probation department upon your release from the Lenawee County Jail. Is that correct?
Yes, ma'am.
And did you do that?
No, ma'am.
How come?
But I did contact them. I called the first day I got out. I called and she said, "Oh, I forgot to have you sign your transfer papers." I live an hour and a half away. I was like, "All right." Yeah, try to report the next time. I couldn't get a ride. I called. I said, "I don't have a ride." Yeah, she said, "All right, come." Then I hung up and I called back. Said, "Here's my phone number of my phone." Then next time came around, I said, "I still don't have a ride." And in the meantime, I was dealing with the guy who killed my son's court date, then my mom not paying rent and have to get kicked out. And it was just overwhelming. It was overwhelming for me.
Okay, so you didn't report.
No, so I didn't even open the letter.
Thank you. All right, and then we mailed you a show cause with an order to appear. Is that correct?
I never opened it.
Oh, okay. All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a probation violation report. Ms. Underwood, our sentencing date is December 12 at 8:15 in the morning. Are you available that day?
December?
Oh, wait, October 24 at 8 a.m.
Thank you, Your Honor. Yes.
All right, so we will set this for October 24 at, I'm gonna do 8:15 a.m. So we'll mail out a notice of hearing. Mr. Mo, someone from the probation department will do an update to your probation violation report. We'll give a copy of that to Ms. Underwood, and then she will review that with you, and then we'll see you back on October 24 at 8:15 in the morning, okay?
Yes, ma'am.
All right, thank you.
That's all I had, Judge.
All right, thank you.
Judge, will that be Zoom?
Do you want to appear via Zoom or in person, Mr. Mo?
It don't matter to me. It's up to you
All right,
guys.
we'll do Zoom. Thank you. Mr. Noe, Mr. Noe.
Middle to them.
Hey, this is Judge Anselone. I am ready for Michael Isaac.
All right, I'll get them out.
All right, thank you.
Bye.
All right, we'll go back and mark those in. So let's see where we're at. All right, John Glazier just popped in and I have a gentleman from MDOC I need to help. All right, so Mr. Owens, I do have John Glazier, so I'm gonna call your case, okay? All right, Mr. Glazier, in the matter of the people of the state of Michigan versus Houston, Eric Owen, file number 25-22420FH. I have John Glazier appearing on behalf of Mr. I have Owen, and I have Phoebe McClure appearing on behalf of the people. Mr. Glazier, how would you like to proceed today?
I was wondering if I could speak with Phoebe for a minute.
You can call her or text her. I need her to, okay.
It is Mr. Sneed's case. I'm just appearing in court. John?
Huh? Oh, Mr. Glazier, I misspoke. It's an arraignment today.
All right.
Have you received a copy of the prosecutor's request for discovery, witness list, and
Yes.
felony information?
We'd waive the reading, Your Honor, and ask the matter to be set for pretrial.
How far out would you like a pretrial?
2 or 3 weeks.
All right, so Mr. Owen, I'm gonna enter a plea of not guilty on your behalf, and we're gonna come back on November 12th for a pretrial, and we will mail a notice out to at MDOC. Where are you currently at, Mr. Owen?
Marquette Point Prison, but I'm going to be transferred.
You are supposed to be transferred. Well, we will find you, okay? So we'll send out a Zoom notice for them, and we'll see you back on November 12th at 8:30 in the morning. All right, Mr. Owen?
All right.
All right, thank you, Mr. Owen.
Phoebe, did you say that was whose case?
Mr. Sneed.
What's my attorney name?
John Glazier.
Can you hear me?
Yep, we can hear you.
I'm Mr. Glazier.
Howdy, how are you?
If you be any chance that you would be able to set up attorney-client call so I can speak to you before my next court date.
I'll probably talk to you that day before we do anything in court.
Do you want to talk to him for a minute now, Mr. Glazier, or? I don't like doing it the day of, but
he's in prison, Your Honor. I have no other way to do it.
everybody else Zooms with them. So, all right, Mr. Owens, he will talk to you before the next hearing, okay? Thank you. All right, so.
You have, oh, never mind.
All right, let's see. I got a jail Zoom. I got. All right, Mr. Knoblaw, you want to come up to the podium?
Yeah.
All right, this is in the matter of the people of the state of Michigan versus Daniel Mark Knoblaw, file number 25-22389FH. I have John Glazier appearing on behalf of Mr. Knoblaw, and I have Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial conference. Mr. Glazier, how would you like to proceed?
Your Honor, we'd ask to have a second pretrial set.
Okay, how far out would you like a pretrial?
2 or 3 weeks.
All right, my next available is November 19, Miss Adams. If I can get a notice of hearing from Mr. Knobloch, November 19 at 8:30 in the morning. So Mr. Knobloch, you're gonna have a seat right behind you. Yep, and then we're gonna get you a notice of hearing for the next pretrial, okay?
Nothing going on today?
You need, well, evidently not, call, when you get done here, schedule an appointment to meet with your attorney, okay?
Okay.
All right, thank you.
Evie, who's this assigned to?
What, Mr. Glazier?
Also, Mr. Sneed.
Okay.
Okay. Okay,
Judge, are you asking for a stipend order for Mr. Glazier?
no, he's in person, I
that's
do
right.
notices.
Yes,
Yep.
I'm sorry.
It's okay. Melissa Moore in the courtroom? I got her in the waiting room. All right, I have a gentleman on a Samsung device. What is your name?
Zachary Rosenberg, Your Honor.
Mr. Rosenberg, Mr. Goldstein popped in and he said he had tried to reach out. That motion is not going today, so he will reach out to him and find out what's going on, all right?
Okay, he might have called a different number. He didn't call me.
Yeah. Yeah, all right. Thank you, Mr. Rosenberg.
Thank you, Ms. Anzalone. You have a great day.
You too. Thank you.
You're all set.
All right, Mr. Knobloch, you're set. Make an appointment with your attorney, okay?
Okay.
All right, thank you. All right. Let's see. Melissa, you want to start your audio and your video, please? I have a Melissa. I'm going to send you a request to start your video and your audio.
Judge, is this Miss Moore?
I don't know. Melissa, what's your last name?
Moore.
Judge, I believe a noli pros was entered on this as she successfully completed diversion.
All right, in the matter of the people of the state of Michigan versus Melissa K. Moore, file number 25-22287FH. I have Michael Dagger Margosian and Phoebe McClure appearing on this case. Ms. Moore, evidently you've been in compliance, so a dismissal was done, okay?
Oh, okay.
All right, good job. Thank you.
Judge, I'm showing that was filed on the 8th. If you don't have it, will you let me know so I can check and see where that is?
So I don't have it in my file, but that doesn't mean it's not in the system.
Okay.
Okay. Do you have a copy, Mr. Dagger Margosian?
I don't have a copy. No.
No, I don't know. All right, Ms. Moore, you're all set. You have a good day.
All right. Thank you.
Thank you. All right. That's a pretty rough looking inmate I have in that Zoom room from the jail.
Looks like he's stuck now.
Who was that?
So much maintenance.
All right. Okay. All right, I don't have.
Mr. Robbie should be here in 5-10 minutes is where they're set.
Did he text you?
No, I was on the hall.
Oh, okay.
So I was
Yeah, I mean, you really take your job seriously. You're like,
But I was looking for Mr. King.
Okay.
My brother King.
okay. All right, so I have so many attorneys and I have maintenance at the jail. I didn't know if you didn't do a good job, they locked you up.
At least for a week.
There's 3 hots and a cot, right? And peace and
Right,
quiet.
there you go.
A little piece of quiet.
All right.
He's better.
Okay.
Right. Hey. Oh, whoops.
Seems pretty secure to me. Should I get that?
Oh my God, this is June.
No. If you get caught, it's like, oh, yeah, it's automatically a felony. Oh, really? Yeah. You definitely never want, when they say, if you have anything past this line, you'll be charged, like you.
You know that you're on live on YouTube, right? Just in case you don't want to be heard up there.
Yeah, no, no.
That was Katie, in case anybody cared out there. All right, who do I have from the jail?
Isaac, Michael Isaac.
Okay, Mr. Noe. And I believe, oh, this is Mr. Hartong. So. Okay, this is in the matter of the people of the state of Michigan versus Michael Anthony Isaac, file number 25-22348 FC, 25-22349 FH. I have Douglas Hartung appearing on behalf of the people, and I have Charles Noe appearing on behalf of Mr. Isaac, who is joining us from the Lenawee County Jail. This is the date and time set for a pretrial conference in this matter. Mr. Noe, how would you like to proceed today?
Your Honor, may I have a brief breakout with my client?
You may. All right, hold on, let me open up some breakout rooms. All right, go ahead and join that breakout room. Mr. Sears, are you here on a specific file?
Yes, Your Honor. I'm trying to turn my camera on now. I am here on, there's a Jaden Olmstead is a juvenile petition that was scheduled today
Okay,
at
la, la, la,
9:30.
la, stop talking then. Just, you could have just said that one. Okay, thank you.
Brian will try and zoom in, but he does have another hearing at this time. I just wanted to let you, the court be aware of that.
Okay. We got that Travis Kelsey like mustache going there, Mr.
Hey,
Sears?
I mean, the wife wanted it. She's liking it. She's making fun of me for it, and I was like, "This is your doing." She came to my office wearing a fake mustache yesterday. Her, Nancy, and Gordon, and Carly all came to my office wearing mustaches. So I'm pretty sure there's a meme of it somewhere, actually.
I'm gonna guess there probably is. So that's cute. Good job. Always obey your wife. Okay.
Hey, we didn't say that in our vows, Judge.
Did I do that wedding? I don't know. All right. So I've got so many attorneys. And salaries. I'm gonna step off for 2 seconds. Here.
Please rise for court style session. And maybe see if
All right, Mr. Noe, we are back with you and your client. So, in the matter of Mr. Isaac, Mr. Noe, how would you like to proceed today?
Thank you, Your Honor. I discussed this matter both with my client and Mr. Hartong. And you know what, Judge, believe it or not, my client, myself, Mr. Hartong, all agree on something. We would like to set this the weapons file for trial And in terms of length, I leave that up to Mr. Hartong, and he's what we want to present proofs, and then set up a final pretrial. And we can also try the CSC case at the same, not try, we can pre-try the CSC case at the same time, and then set a trial date on the weapons case. So we don't need a trial date for the CSC case, but we do need a trial date and a pre-trial date. Does that sound correct, Mr. Hartong?
Strangely, yes, it does. I would say it's gonna probably dip into a third day, just, so you know, for scheduling purposes.
Okay, so my audio is like wonky. Miss Adams, could I get the red book, please? So we are setting file number 48 or 49 for trial first. The FC should go to trial first, right?
But we don't have the labs back on that. That's why we thought we'd set the other one first, Your Honor.
Okay, so we're gonna
I agree.
set the 49 file for trial.
Correct.
And how long do we need for that trial?
I think it's gonna dip into a third day.
3 days?
Yeah,
Okay,
maybe not the full 3, but
all right. Miss Adams, I apologize. Could I get the 26 book, please? Okay, so. So I can do Tuesday, January 27, starting at 9 a.m.
works for me.
Works for me.
Okay, so let me get this filled out. All right, so if we do trial. That way, if we have deliberations, that can go into Friday. All right, I'm going to set a final pre-trial conference for Wednesday, January 14 at 8:30 in the morning on both files. And I'm going to require that jury instructions and voir dire questions be provided to the court by January 9. And again, we expect that the two of you will work together to submit a finalized copy to the court. So if there's any issues, we can address them at the pretrial. And I will set the motion deadline for January 14 of 26. And is there anything else I need to address?
We'll receive the scheduling order, Your Honor.
Yep, I just filled it out and I will make sure to get a copy. No, I won't. Miss Adams will make sure that you guys get a copy.
Thank you.
So I've completed that. We'll get a copy out, and anything else we need to address?
I don't believe so, Mr. Noe.
No, that will be a 9 a.m. start every day of the trial, correct? I just want to make sure.
No, well, it's a 9 a.m. trial start date. I expect you here about a half hour early.
Yeah,
Wednesday is our criminal docket, so the trial wouldn't start till 10:30.
Okay. Okay.
Okay, all right, do you want the pretrial in person?
I don't need it to be. I'm fine either way.
Okay, all right, so we will see you back then on that day, if not sooner. Obviously, I'm available to the attorneys if they need anything. All right, thank you.
Thank you.
Thank you, Your Honor.
And Mr. Adams, if you get a chance, I need like 30 more criminal spread scheduling orders. So I don't think Miss Rabbit is coming. Okay, so next year's Rhonda Underwood. Rhonda Underwood. Miss Underwood, are you at your device?
Yes, Your Honor.
The only thing I have left are the pickups. Is that correct?
Betts and Sarabia, I think.
Yes, Miss Betts is here. Did you want to scoot in and talk to her?
Your Honor, I'm still not done down the hall. Can I
Oh,
check
we'll
in
go
there?
finish down the hall then.
Thank you.
Miss Sarabia is not going to show up according to her daddy. So, okay.
Thank you.
Thank you. In the matter of the people of the state of Michigan versus Jasmine, was it her dad or her brother?
Brother.
Okay. So in the matter of the people of the state of Michigan versus Jasmine Elizabeth Sarabia, file number 25-22249FH. This was a date and time set for probation show cause. Miss Sarabia was ordered to appear. Her family was here and but she has not. So I'm going to issue a bench warrant for her arrest, and I will set a bond of 50,000 cash. All right. So, so Miss Underwood's going to go take care of Judge Olsaver's court. When she's done, she'll come speak with you. I am waiting still for my defense attorney on your matter, and I'm going to step off the bench. So, Miss Adams will let me know if he's okay.
Mr. Murphy might be ready to take it.
Huh?
Mr. Murphy just walked.
Mr. Murphy, I'll be right back.
Thank you, Your Honor.
Oh, we're just starting to.
Stressful. Please rise. Your court's now in session. And you may be seated.
All right, so Mr. Murphy, you have Isaac Powers. Are we ready on that one?
I have William Powers.
Oh. You say Isaac. Hold on. Is William Powers here? Yeah. Yeah.
No, William Powers is in custody. I was going to ask that we address that towards the end if possible.
He's in jail?
Yeah.
How about we just say that? Okay. So let me call the jail.
The jail sheet was just wrong. I think it mixed up two names.
Okay. Hey, this is Judge Ann Saloon. I am ready for William Powers.
Okay, I'll get him.
All right, thank you. Isaac Rosales. All right, we can take care of him. All right, this is in the matter of the people that stand next to your attorney. Okay, Isaac Jacob Rosales, file number 25-22346FH. This is a date and time set for a pretrial conference in this matter. I have Matt Murphy appearing on behalf of Mr. Powers, Mr. Rosales, and I have Phoebe McClure appearing on behalf of the people. So, Mr. Murphy, how would you like to appear or proceed on behalf of Mr. Rosales?
Your Honor, this case began September of 24. At that time, Judge Schaefer ordered competency evaluation of Mr. Rosales, so the case took some time for that to occur. Now, Mr. Rosales is charged with an incident involving he's charged with possession of a pneumatic firearm or a BB gun, R&O stemming from that. So he's got, and then assault with dangerous weapon, 2 with that BB gun. He has 1, 2, 3, 4 counts of the assault with a dangerous weapon, 1, 2, 3 counts of the R&O, and 4 counts of the felony firearm for the possession of the BB gun. Now, downstairs in district court, the offer had originally been for Mr. Rosales to plead to 1 count of felonious assault and 1 count of resisting obstructing officer. We had examinations that there was a delay due to an unavailability of a witness or multiple witnesses. Said again, at the time of the examination, per my recollection and per my notes, the offer by Mr. Bayanetto was for him to plead to 2 counts of RNO, felony counts of RNO, would kill a boot to no upfront jail. I spoke with my client about it at length down in district court about my issues with the case. I mean, quite frankly, there's a lot into it, and I reviewed it quite extensively. I explained the issues I believe I had in the case. My advice at the time was to deeply think about whether or not to waive the exam. Now, Mr. Rosales has said to me today that he was confused about what the offer was downstairs. He thought he keeps requesting to be able to plead to what was downstairs. And again, as I expressed, there was no offer for misdemeanor by Mr. Bayanetto, and we had the examination set and it was waived. But Mr. Rosales, again, today is expressing.
So, okay, I gotcha. Miss McClure, are you handling this case today?
I am for Mr. Bayanetto, and I'm just getting caught up on the notes here.
Okay, so it sounds like there was an offer, there was a forensic examination, there was a waived prelim. So is the offer to what?
I'm showing to 2 counts of RNO.
All right, does your client want to plead today?
No, Your Honor. He was asking, again, he has concern. I mean, first he was requesting an attorney. He is expressing to me in the hallway that he has issues with the case coming upstairs, the waiver ultimately of the preliminary examination. So that's why I expressed on that to Your Honor today. I'd also been asked for another pretrial, which either way, to have further discussion with my client, whatever happens about, again, the offer, and clarify things. But I wanted to express on the record his issue. I think he was trying to suggest that his waiver was involuntary or unknowing.
Okay, so, all right, so Mr. Rosales, obviously you have availed yourself of public defenders. They are very good attorneys. They're well-trained. They do their very best. If you are not satisfied with your public defender, you have every right to go hire an attorney, but you don't get to pick and choose, okay?
Yeah, that's fine. So.
Okay, and Mr. Murphy is a hardworking attorney. If, at this point, the plea offer is to plead to 2 counts of RNO, which are high court misdemeanors, which carry a maximum penalty of up to 2 years in prison, but obviously the guidelines never carry a prison term. So you could be looking either at a county jail term or probation or whatever. I'm explaining this to you. Your charges are assault with a dangerous weapon, a 4-year felony, 2, 3, 4 counts of felonious assault, which carry a maximum penalty of up to 4 years in prison, 2 counts, 3 counts of RNO, which carry a maximum penalty of up to 2. And then we have felony firearm, pneumatic gun.
BB gun, that doesn't.
It doesn't matter. Listen to me. Those, are you gonna listen to me or do I have to put you in jail to calm down? It's your choice.
I'll listen.
Okay. Those felony firearms, doesn't matter if it was a BB gun that doesn't work, okay? Doesn't matter. So it says a pneumatic weapon. So anyway, those are felony firearms. So those are an automatic 2 years in prison before you serve any other sentence. You got that?
Yes.
Okay. And you have 1, 2, 3, 4 counts of those, okay? So you would serve, if you got convicted, you would serve a flat 2 years in MDOC and then whatever sentence I give you on the other counts. You got it? You fully understand, yes or no?
As long as I can tell the truth, the whole truth.
Well, that's what we hope for everybody.
I just asked you.
But do you understand the words that I just said to you? Okay.
In college, I understand.
Okay. So, Mr. Murphy, I'm going to give you another pretrial date. And I'm going to set this out to, did we get a forensic exam back?
Yes, Your Honor, there was a forensic, you yourself competent.
Okay. Okay. So I'm going to set this for November 19. Miss Adams, could I get a notice of hearing from Mr. Rosales for November 19 at 8:30 in the morning?
Yes.
So.
And Judge, could you order a transcript, or maybe that's something we have to do, a transcript of the waiver in the case that Mr. Murphy wants to make a motion for remand?
Do they need to fill out something, Miss State?
Yeah, they need to get something.
Yeah, you gotta fill out something and submit that to, I think, district court, right?
Yes.
You gotta submit that to
Okay.
district court.
Okay.
Stop talking. We don't talk over other people. You understand? Okay, hold on. So they're ordering a transcript of the waiver down in district court. The prosecutor will, through the district court clerk or whatever court that was. We're gonna get your client a notice of hearing for today, for the next court date. So don't lose that. You won't have to do a stipend order, okay? And then Mr. Rosales, you need to talk to your attorney. You need to talk to your attorney because, you know, even if you didn't commit some crimes, sometimes you go to trial and you get convicted of some and not others, right? So, very good. Talk to your attorney because I can't give you legal advice. Got it? So have a seat right behind you and we're gonna give you that notice. Here's your notice.
I just want to notify her of recent events.
I don't want to know about your recent events. This is,
My mother had passed.
no, I don't know. Go talk to your attorney.
All
right.
And Judge, what was the
Okay,
next
thank you.
pretrial
You're all
date?
set. You can go. What, Ms. McClure?
What was that next pretrial date?
November 12 at 8, or what it is, it say November 12?
Yeah.
No.
You said 19, Judge?
19th?
Yes.
November 19 at 8:30 in the morning.
Thank you.
Your Honor.
Thank you. Thank you. All right. Do you need another forensic?
I think at this point, I might, it seems that I never.
If you meet with them and determine you do, just let me and
Everyone's
Mr. Clerk know. Yep. All right. So, who do I have from the jail?
William Powers.
All right. Let me pull his file. This is in the matter of the people of the state of Michigan versus William Powers. This isn't the one you have to go get the other prosecutor for. That was Caleb
Nope,
Daniels,
this was
right?
not Your Honor. This is the one
All right.
we recently had a bench conference on with you.
Okay, file number 24-22033FC. I have Matthew Murphy appearing on behalf of Mr. Powers, and I have Phoebe McClure appearing on behalf of the prosecutor's office. This is the date and time set for a final pretrial conference. Looks like there was a request by Mr. Murphy regarding using the defendant's name in the jury instructions. So I do have proposed jury instructions, proposed voir dire questions from the people that I just, let me see, and you've gotten yours in?
Yes, Your Honor.
Okay,
Yes,
so.
and Judge, Mr. Murphy did sign a stipulation to ours, but I think reserving the right to discuss the name or using defendant in the jury instruction.
Okay, so Mr. Powers is charged with 2 counts of criminal sexual conduct, first degree, which carry a mandatory lifetime electronic monitoring as well as life in prison, and 1 count of criminal sexual conduct, second degree. All of these do, if he were to be convicted, allow the court to impose consecutive sentencing. So I could impose a life sentence and stack it on another life sentence. So,
and Judge, at our Cobb's conference on the 9th, as to the offer, you did agree to a Cobb's sentence of the bottom of the guidelines at 36 months.
Okay. All right. You said 36? Okay. I had
Yes,
45.
that was what
Okay.
the Cobb's evaluation was.
And that
I
was
just
to
wanna
2
make sure that was-
counts of CSC third.
That is correct.
All right. So the plea offer was to 2 counts of CSC third degree, which are 15-year felonies.
Yeah.
Correct.
And then there would be a Cobb's agreement to the minimum of 36 months to 15 years in Michigan Department of Corrections. That plea offer is open until today. And so, Mr. Powers, you understand there is a plea offer out there that guarantees you a sentence of 36 months to 15 years. Do you understand that?
Yes, Your Honor, I do.
And that the charges against you, if you were convicted, would carry a maximum penalty of stacking life offenses. Do you understand that?
Yes, Your Honor, I do.
Okay. And Mr. Powers, I know Mr. Murphy is very good about meeting with his clients and speaking with his clients. And you've been able to speak with him and you have no more questions about those?
No, Your Honor.
All right, so Mr. Murphy, are we continuing to try?
Yes, Your Honor, well, I guess quite frankly, I wanted to place on the record my understanding of what I relayed to my client. Because I was pretty clear to him and open about him what my understanding from the cops conference was. Again, that the court would agree that if you pled to 2 counts of CSC 30, it would be 36 months. After the conference, I wasn't sure those may be below the guidelines or maybe the low end of the guidelines after what Mr. McClure had said. Now I talked to, again, what Your Honor had expressed. I talked to my client right after that and expressed to him that my understanding was Your Honor had again indicated that these can be consecutive, and it would be probably the intention, if he was found guilty at trial of these accusations, that will probably be the more appropriate sentence, plus a more top end of the guideline range if he was found guilty of what these allegations are. So I'd express that to my client so he's fully well aware of what we'll be looking at trial. Now, I do apologize for taking up some of the court's time, but my client had wanted to express some things on the record. So my client was asking, now, first of all, this deals with my client's phone, access to my client's phone. We had addressed this before when we had the hearing about the use of the term victim briefly after the record on that. I had requested access to my client's property at the jail. I sent an email to the jail about that, trying to figure out how to do that. Also expressing a desire to meet with my client for trial prep, possibly at one of the jury rooms in the court. They relayed that message to Mr. McClure. That was relayed to Detective Putnam. Detective Putnam called me that day. I spoke with him. Detective Putnam relayed to me that he had no reason before to search the phone. He wasn't sure why I wanted to look at the phone. It had been sitting in Mr. Power's property for a year at that point. I was confused because it was my client's property. I received nothing but the jail telling me I had to do anything about getting at my client's property. And again, just looking through my client's property with my client and engaging in trial prep. So I expressed at the hearing, we clarified it was not seized evidence. It was in his property. After the hearing, I expressed that my client did not give consent for a forensic search to be done of his phone. He was just wanting me to look at stuff on his phone with him. So I expressed it to Detective Putnam. Detective Putnam drafted a search warrant to search Mr. Power's phone. I apologize. I don't have the search warrant here, Your Honor, because ultimately I have not received the forensic dump, anything from that phone at this point. So I have nothing to file a motion to suppress on. I believe the search warrant is highly inappropriate and insulting to the defense because in the search warrant it indicates that one of the reasons for wanting the phone is because if defense counsel was to have access to the phone, there would be deletion of evidence and concern about that. I have a grave, again, that's insulting to defense counsel to suggest that if I had access to my client's phone, I would be deleting anything. I don't understand how looking at anything on my client's phone, which is the same thing that Detective Putnam does during the investigation. He looked at other people's phones. No concern about deletion of evidence there. But again, the fact that I would look at it, the notion that because of me looking at it, screenshots, text message conversations, I would delete that, I again find insulting. I am an officer of the court. Any deletion of evidence I would find would be a felony, and any evidence I was going to use, I'll be required to disclose during discovery. So I wanted to express that again. My client told me yesterday, and I apologize to Mr. McCord because I hadn't intended to address this on the record until my client expressed to me his deep concern about the fact that we do not have the phone information, the phone dump. There was stuff on there he wanted to review with me to confirm things. And again, which would be normal trial prep with a client that was not in custody. As I expressed before, Your Honor, I had concern about my client not having a PR bond. Mr. Coast had given a report about him not needing it. So, Your Honor, again, Mr. Powers was wanting me to request an adjournment of a trial until we get his phone dump because Mr. Powers believes that that's imperative for properly preparing for a trial moving forward. And I also wanted to express, again, I apologize for the length of it, but the facts I understand leading up to the requirement of that phone.
Ms. McGrain, are you in your office? Can you check your chat? All right, Ms. McClure.
Yeah, if I could respond, I think just to clarify what the search warrant says about deletion of evidence, what Detective Putnam's concern was inadvertent deletion of evidence, not anything willfully or intentionally. When a phone is turned back on after being in storage, there is the risk that evidence or items on that are expired, or I guess, I don't know how the technology specifically works, but things can inadvertently be deleted or removed from the phone. The way that the police can search a phone, it can maintain the integrity of the device and make a exact copy of the device without the risk of turning it on and delete, or, you know, inadvertently deleting items. Not, again, not intentionally. That was not ever the insinuation. So I just wanted to clear that up. As for the request for an adjournment, I guess I would just
Well,
ask that.
hold on. Do we have the information on the phone?
We have the search warrant. We do not have anything back from it yet, but I want the opportunity to speak with Detective Putnam and see what the status of that is and how long that's going to take him.
Okay, because he has a right to that. I mean, Mr. Murphy does have a right to that. And I can understand perhaps whatever the, you know, what the detective is saying, but that, you know, he didn't do a search warrant for before. So, you know, he probably needs that in the next day or two and the phone to look at.
Yeah, I can check the status of it with Detective
I mean, if
Putnam.
they've
That's all
already
I
done
can
the
do.
dump, there's no reason Mr. Murphy can't view the phone.
I don't know if they have it. That's what I want to check the status of.
All right, I'm gonna set this for tomorrow morning at 8 o'clock.
Thank you, Your Honor.
And we'll get the status then. So, Mr. Powers, we'll see you back tomorrow morning at 8 o'clock, and Ms. McClure, you as well. Thank you. Yeah, and I'm gonna have Mr. Powers brought over in person, Ms. Adams, so that Mr. Murphy can meet with him.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
We'll do the notice. Ms. Adams, tomorrow morning at 8 o'clock.
Thank you, Your Honor.
Okay, so let's see. I want to make sure that all the good stuff done. Julia Betts, Rhonda Underwood. All right, we are back on the record in the matter of the people of the state of Michigan versus Julia Betts, file number 23-21519FH. I have Rhonda Underwood appearing on behalf of Ms. Betts. Ms. Underwood, thank you so much for coming down and meeting with Ms. Betts. So how would you like to proceed on these violation of probations with Ms. Betts?
Your Honor, the violation of probation is already set beyond, I believe, where it's set so we can ascertain what's going to happen in district court. I would ask that these matters be set for that time also. I believe Ms. Betts has proof that she's attending AA. She has her own things where it says negative. So, which she will present to Ms. Tetsky, but we would ask that this be set for that time as well. And Ms. Betts did show up today. She
always shows up. Ms. Betts always shows up. All right, Mr. Coast, we're on the matter for Ms. Betts. Ms. Betts, do you have that documentation with you now?
Yeah, I have my AA paper, and then I just have this.
No, proof that you didn't tamper with the device, or proof that you didn't consume alcohol.
I gave Sarah my schedule for work on the 28th, and then I don't know the date and times for new ones.
Okay. So the allegation is you tamper with your device on 3 different days for longer periods of time. So we have September 28th from 3:24 p.m. until 8:59 p.m. October 3rd from 3:47 p.m. until 10:49 p.m. and October 5 from 6:40 p.m. until 10:17 p.m. So Mr. Coast, what does tampering mean?
Tampering could be a number of things, Judge, where maybe she tries to put something in between the device and her leg. Regardless, so I mean, on all 3 tampers, they did detect alcohol. So that's where we're at.
All right. So Miss Underwood, it's not like a bad test. It's a long period of tampering that the allegations are for. And she is a member of recovery court, which is concerning. And then also, you know, she does have a child. So, you know, she's wearing the tether because she got allegedly intoxicated and committed a crime. So
Your Honor.
where are you working at?
Buffalo Wild Wings.
And what are your shifts?
Sometimes I work like, on the 28th, I worked a double, so I was there from noon to 8 p.m.
Doesn't
And
mean,
then,
okay, but they serve alcohol.
Yeah, and then I work like mornings, like I'm supposed to be in at 10:30 today to 4. And then other times I work 4 to close, so I have different shifts.
Your Honor. So what I'm gonna tell you is I'm not gonna lock you up today, although I was going to. I want you to know that. But if there is one more tampering or one more false number, I'm locking you up until we have your trial or you plead on this violation. You understand? It's very easy to go from one substance to another.
But I'm not doing anything.
I don't know, but so understand, and if there is a tampering, you better go get a couple PBTs done, like right away.
And I changed to portable breathalyzer like 8 hours, like 3 times a day or something. So I'm not dreaming.
Okay, well, you know, Mr. Coast, can we have the device checked to make sure it's working appropriately or switch it out?
Judge, I actually like the remote breath just because it takes a picture of her. And it also gives a reading.
So 3 a day?
Yeah, I mean, I'd be happy to do
Okay.
that. We could switch it from
So-
the scram over to the remote breath with
Okay.
3 times a day drug testing.
Okay,
Or I'm sorry, not
so
drug testing, but the breathalyzers.
is 3 times a day enough?
I believe so.
Okay, so you're gonna go meet with Mr. Coast in the hallway. She's gotta be at work at 10:30.
Very good.
And we're gonna figure this out, but one violation.
Darren, where does
You're
she
off to
do this
rehab.
at?
It will be over at JSG.
Okay, so she just needs to understand it's gonna be, if she's working, she's gonna be required to leave work to go do it.
Correct. I mean, she
So
could
we don't-
actually do it on the job site, but yeah.
She has it, it's a portable device, Ms. Walsh.
Gotcha.
Got it. All right, so what's our date on the other case, Ms. Underwood?
I'm sorry.
Do you know when our court date is on our other file?
Judge, this file has a VOP pretrial on October 29th at 10:30.
All right, we're gonna set it for October 29th at 10:30, you said?
Correct.
All right, so you got another hearing October 29th at 10:30. We'll move this to that. Okay, all right, go meet with Mr. Post in the hallway. Thank you, thank you. Ms. Underwood, Ms. Sarabia failed to appear, so I issued a bench warrant set bond in the amount of 50,000 cash. All right, Mr. Murphy. Mr. Fry, I'm sorry, you've been lurking and I did not know you were there, but you are on, hold on.
I'm on a juveniles case, Your Honor.
Yeah, but what about, Finley? Are you here on Finley?
That was set for today. That is my case, yeah.
Yeah, so in the state of Michigan, matter of state of Michigan versus Noah Michael Finley, file number 24-21954FH. I have Brian Fry's got a lower P number. Brian Fry appearing on behalf of Mr. Finley and Alexander Bayonetto appearing on behalf of the people. So there was a stipend order prepared by you, Mr. Fry, setting it for today at 8:30 in the morning. I do not have your client. I don't have any men in the courtroom. And I don't think he's in jail. Noah Finley?
Mr. Murphy's taking a plea next door, then back.
Okay.
He's in the hallway, Judge.
Huh?
He's in the hallway.
Oh, Mr. Fry, he is here in the hallway. Where are you, Mr. Fry?
Wasion, Ohio, in the police department.
All right, hi. Okay, this is in the matter of the people of the state of Michigan versus Noel Michael Finley. So, Mr. Fry, I do have Mr. Finley here. How would you like to proceed today?
Yeah, so Your Honor, if it's possible, we'd ask for a brief adjournment as I did the stip in order on this, but for some reason it wasn't on my calendar and I didn't have a chance to talk to Mr. Finley prior to this hearing.
All right, so
That's
Ms.
my fault.
Adams, I'm gonna set this over to November 12th. Could I get a notice of hearing from Mr. Finley?
I'm sorry, Judge, what date?
November 12th at 8:30 in the morning on Mr. Finley. So
November
Mr.
12th.
Finley. Oh, you're
Your Honor,
gone?
I'm gonna be gone that day, Your Honor.
November 19th?
That works.
All right, November 19th. So you need to call Mr. Fry's office and set up a time to meet with him, okay? All right, thank you. All right, have a seat right behind you and we will get you a notice of hearing. So, Mr. Murphy, here. Thomas Garza. All right, where'd Mr. Murphy go next door?
He's taking a plea next door for signature.
Okay. Is the juvenile in custody?
Juvenile's in the hallway, Your Honor.
Okay. All right. So as soon as I get him a notice of hearing, I'm going to close the courtroom. All right. Don't look sad, Mr. Sears. At least I said Travis Kelsey and not Jason Kelsey. Although Jason Kelsey is my favorite.
Yeah, I like Jason. I mean, he's hell of a player, like the beard. I'm looking sad because I'm not in my office because there was a meeting outside my office and I got a text message, Nick, you're too loud. Go to my office.
All right, thank you. Make sure you call and make an appointment with your attorney, all right? All right, so we are going to go off live stream at this time and close the courtroom.